Hi, I'm Burt True with True & Associates. I promised you last week that I would this week discuss liens on personal injury settlements. First, I'll explain what a lien is, and then I'll talk about the different types of liens and how to reduce them so that you receive more money for your personal injury settlement. A lien is a charge against a fund of money. The fund of money is your personal injury settlement. So, a lot of my clients are surprised to find out when they're injured that all these people get in front of them when it comes to being paid for their injuries, compensated for their injuries. Who are these people and why do they get money before the injured person? Well, the first one you've probably heard of, they're called Medicare. Medicare the federal government is also involved in the Medicaid program. And in Missouri, Medicaid is now called Missouri HealthNet. Medicare is a government health insurance program, or not really health insurance program, but a program for paying the healthcare expenses of a large portion of the population. Anyone that's old enough to qualify for Medicare is on Medicare. But there are also a lot of other people who are on Medicare by virtue of being on disability or for other reasons. And then there are all the people who are on Medicaid as well. Now, the government has enacted laws that say the government gets paid back out of your personal injury settlement before the injured person. But a lot of people don't realize that if the government gets paid back this way, they have to pay their pro rata share of the costs of procuring the settlement. So what that means is the government has to pay their pro rata share of your legal fees and expenses. So here's how it works. Your lawyer maximizes the amount that you recover from the auto insurance company. At the same time, Medicare is paying your expenses, but as you know, Medicare doesn't pay the amount that your doctor charges. They pay a lot less, which kind of makes you wonder, why doesn't the doctor just charge less if he's going to accept what Medicare pays? But in any event, Medicare reduces your medical expenses by simply paying less, and hospitals and doctors are required to accept the amount that Medicare offers them. Otherwise, they can't take Medicare from anybody else, which is not something that they want to do because Medicare covers so many people. So Medicare reduces your medical expenses by paying a lot less than everyone else has to pay. And then further, your lawyer negotiates with Medicare to reduce the lien amount, in effect forcing Medicare to pay their pro rata share of the legal fees and expenses. The end result of this is that you receive more money, net money in your pocket for your personal injury settlement. Now, what about the next one is hospitals. Hospitals have also gone to the state legislature and got laws enacted that say that they get to get paid back before the injured person. So how does this work? A hospital will assert a lien. Now, if the hospital accepted Medicare or Medicaid, Missouri HealthNet, something like that, obviously they can't assert a lien. So your lawyer will tell them, look, you can't assert a lien for your bills and get paid by Medicare. That's absolutely wrong. So that's one way to get rid of the hospital's lien. But also, the law in Missouri says that hospitals, first of all, it has to be a Missouri hospital. So if a Missouri resident is taken to a hospital outside the state, such as the Regional Medical Center in Memphis or Kansas University Hospital, those hospitals are not entitled to assert Missouri liens because it has to be a Missouri hospital. Also, and secondly, the hospital has to be supported by charity. So if the hospital isn't a charitable supported by a charity, then it's not entitled to assert a lien under Missouri law. And finally, as I explained before, if somebody else, like health insurance or Medicare, has paid the bills, then the hospital can't assert a lien in a situation like that. Again, your lawyer will negotiate with the hospital to reduce the amount that they get paid back. These amounts are fully negotiable. And in a lot of cases, I have gotten hospitals and doctors to accept a lot less than what their lien amount was. And this is simply because they know that if they were being paid by health insurance or Medicare or anybody else, they wouldn't be able to charge as much. And finally, the last one, and this is kind of really the most complex one, is your health insurance. Your health insurance will try to assert a lien, and they'll say that even though you paid health insurance premiums, and even though we never specifically told you that you're not going to have health insurance coverage if you're injured in a car wreck, if we pay your bills, you have to pay us back out of your settlement. Well, first problem with this is the health insurance company, I would say in about 50% of all cases, is simply lying. They're not entitled to a lien. And the reason is because the law is very complex and changing in this area. Health insurance companies will try to assert a lien under a federal law called ERISA. The reason why they have to assert the lien under a federal law is because Missouri state laws prohibit health insurance companies or anybody from taking an involuntary lien or even a voluntary lien on a personal injury settlement. So they'll try to go to this federal law saying that it preempts the state law. In other words, takes precedence over the state law. But the court cases have held that there is only federal preemption of state law under ERISA if the health insurance plan is fully self-funded. So if any portion of your company's health insurance plan is funded by insurance, they're not entitled to an ERISA lien. Now, of course, they won't tell you this. Try that. Go to your HR director and ask, is our health insurance plan funded in any way by insurance, or is it fully self-funded by the company? They won't tell you. But you can find this information out from a document called the Form 5500. It's a public document that health insurance plans are required to file. And it will disclose whether or not there's any insurance component. And I have requested many of these and found that there's insurance components to these health insurance plans, but they'll still try to assert a lien. Secondly, they will try to assert liens in situations where the plan doesn't provide for it. The plan has to state that there is a subrogation claim. And I will, your lawyer, if it's me, I'll request the full plan, not the summary plan description, which is that little document they hand you when you sign up for health insurance. I'm talking the filing cabinet, which is the real plan. That's the one you have to get, and that's the one that contains the documentation of the subrogation provisions, and that has to be gone through. So there are a lot of court cases and laws changing with respect to whether a health insurance plan can assert a subrogation claim or a lien on your personal injury and try to get paid back before you get paid back. And this is where a lawyer can really add value. I have reduced a lot of health insurance lien claims through negotiation because they simply can't. They don't believe they're going to win in litigation, and they don't want to establish a bad precedent in one case that would apply to all their other cases where they're frankly asserting liens they're not entitled to. There are a lot of other laws that provide different people with so-called liens on personal injury claims, and each one of those esoteric laws has to be gone through and researched and determined whether the health insurance or medical provider has complied with that law. And this is where a lawyer can really add value. On the one hand, I maximize the amount that you recover from the auto insurance and then minimize the amount that you have to pay back to medical providers and other health insurance companies and the government. And that way, that results in more net settlement to you at the end of the day. I'm Burt True with True & Associates.